Quickly, constitutional law is what we are coming to look at today. When you hear constitutional law, the first thing to come into your mind is constitution. Constitution. Constitutional law. Constitutional law. Constitutional law. It is not difficult, but you have to get time to study it, to read cases of national interest, and to listen to current affairs. If you don't like current affairs, if you are not following parliament or politics and those things, then constitutional law, you might not like it. So sometimes in class, you will see the politicians who are talking back. The politicians under constitutional law, they will get a lot to say than those who are not politicians, because they have been following the current affairs, or let me say the politics. So constitutional law, if you're a politician and then you don't pay much attention or critical attention to constitutional law, then I don't know how you want your future to be. Because as a politician, if nothing at all, you should know constitutional law, because constitutional law is one way or the other what makes a politician, right? So constitutional law is very important. So before you appreciate a constitutional law, then you have to be a person who has a key interest in national matters or national issues. So constitutional law, it is also a public law. And then let me say, constitutional law move hand in hand with what is called administrative law. It moves hand in hand with what is called administrative law. But for the purpose of our discussion, we are looking at constitutional law. Today, we are looking at nature, scope, and sources of constitutional law. Nature, scope, and sources of constitutional law. Nature, scope, and sources of constitutional law. Once again, my name is Possible, and I've been your tutor up to now. So make sure to take a sip of water, grab your pen, your jotter, and write something, because we are going to learn today. What, therefore, is constitutional law? When we say constitutional law, what does it mean, constitutional law? Well, does constitutional law mean that, does constitutional law simply talk about we holding the constitution, or just lifting up the constitution up and then say, oh, okay, this is the 1992 constitution of the Republic of Ghana, this is the constitution of America, so that's constitutional law? Or what at all is constitutional law? When you talk about constitution, what does it entail? What does it talk about? What at all is constitutional law? So by the end of the lesson, you should be able to introduce what constitutional law is. You should be able to explain constitutional law. You should be able to list the characteristics of a constitutional law. And then you should be able to list the sources of constitutional law. Finally, you should be able to explain the classifications of constitution. Remember, as we always do, these listed points shall be discussed seriatim, or chronologically, or in order. So that is how it is going to be discussed. Let us begin with the item 1, which is the introduction. Now, when we talk about constitutional law, it emerges from the word constitution. But remember that, in fact, as many subjects are begun by an attempt to define what the subject is in terms of its constituent elements, constitutional law is of no exception. It is of no exception, because we know in any aspect of our endeavors, even when we're learning contract law or criminal law, we try to, or we made an attempt to define what the criminal law or the law of contract means, what it is and what it is not, what it covers, the nature, the content, the scope, the size, the form. We look at all of them, what it is and what it is not. So we are trying to say that when we come to constitutional law is of no exception. It is of no exception in the sense that we try to define the subject in terms of its constituent element. Constitutional law is of no exception, because an attempt has been made in the past to define the tenant and the scope of the subject by various authors. So a lot of authors have contributed to what is called constitutional law. Most of them have tried their best possible to define the term or the subject constitutional law, right? So that is how it is. So we are saying that this is the reason why we, as learning colleagues, we stand today to assess the various learned authors' views. So we are coming to assess the various learned authors' view, what the various learned authors have said about constitutional law. If you just join, we have not gone far. This is the first slide. So far as the lesson is concerned, we have not entered at all. So we are now going. This is the introductory aspect out of what we are supposed to expect. Out of what we are supposed to expect. I'm doing you a favor. Next time when you are late, we will leave you and go ahead of you. So that is how it is. We are just on item number 1. We are introducing it. And then we are saying that number 2, when you look at the item, say number 2, we shall discuss what a constitutional law means. What a constitutional law means. So we are saying that we are studying constitutional law, the nature, the scope, and the source of constitutional law, because every subject needs to be understood. We have to understand what it is and what it is not, right? That is why it is quite necessary for us to know the nature, the scope, and the sources of constitutional law. In fact, characteristics is also part. All right. So what therefore is constitutional law? Constitutional law, is it the 1992 constitution that we are holding? Hey, I have 1992 constitution. Is that one the constitutional law? Or there is more to it? Or there is more to it? What therefore is constitutional law? We are saying that different scholars have given their own definitions on what constitutional law is. Undoubtedly, inarguably, undoubted, unchallengeable, right? Different authors have given their various opinions, right? Over the years, there has not been any uniformity in the definition of constitutional law. Yes, can I tell you something? As harder as different authors try to add their voice to the definition of constitutional law, the difficulty they make it to be. I'm telling you this. As harder as they try to define, to explain, to tell us what a constitutional law is, the harder they contribute to the topic. Or let me say, the harder they make the concept or the subject of constitutional law becomes. So as we will see it soon, or as will be seen soon, some of these definitions are not only narrow, but have also raised additional conceptual difficulties. Some of the definitions are narrow. Some of them have also even raised additional conceptual difficulties, whose clarification may be essential for an understanding of their tenant. So that is what I've said. As harder, or the more they try to contribute to the concept of constitutional law, Mr. Nkrumah Evans, please, you are writing, please. You are writing on my screen, I beg. So the more they try to add their voice to the concept, the more it becomes very difficult. They make it difficult. All right. So like we're talking about, the more they try, the more they add to the conceptual difficulties of the topic. So they are trying to define a constitutional law, but they are even contributing to its difficulty. So that is how it is. But let us look at what Jandor and Griffiths, all these things are constitutional law books that you'll be meeting. Jandor and Griffiths, in the book of a source book of the constitutional law of Ghana, volume 2 of first edition or edition 1. Let us look at how constitutional law was being discussed. The constitutional, I think I have Amma here. Amma, I think it was Amma who helped me the other time. Amma, cancel Amma, or she's out. Okay. Then Kukwa, you can help us, so Kukwa. You can help us do the reading.
Answer, your voice was not.
So the constitutional law of a country is not simply from Jandor and Griffiths. It's saying that the constitutional law of a country is not simply the law. Wow. Constitutional law of a country is not simply the law. So constitutional law of Ghana is not simply the law. Hey, what do you mean by that? Constitutional law is not simply the law. But what? Okay, it's not simply the law of a constitutional document or documents produced by or for that country. So when we talk about constitutional law of Ghana is not that hard-bound book that you're holding. It is not that white and black book or black and white book that you're using. Constitutional law of Ghana is not simply the law of a constitutional document or documents produced by or for that country. It is not that just constitution. 1992 constitution. 1992 constitution. That is not just a constitutional law. Properly understood, the study of constitutional law of a country should encompass an inquiry into the entire process of the creation, number one, of the creation, number two, adaptation, number three, by whatever means, number four, or number three, by whatever means of institutions, and number four, practices for the governance of a country. So it means that it is talking about the creation. Number one, creation of institutions, creation of the arms of government. It is a constitution that creates the SRAJ, Commission of Human Rights and Administrative Justice. It is the constitution that creates this one, DOVSU, Domestic Violence of Victim Support Unit. It is the constitution that creates a Forestry Commission. It is the constitution that creates Electoral Commission. It is the constitution that creates the Office of the Attorney General. It is the constitution that creates Auditor General. It is the constitution that creates. So we are saying that it talks about an inquiry into the entire process of the creation. Entire process of the creation. What is the idea for the creation of the Electoral Commission Office? What is the idea behind this? What is the idea? You won't see all of them in that black and white sheet that you are holding, that hardbound book that you are holding. But remember, anything that has been captured in the 1992 Constitution has a history. Number one of them is the just ended case between Ato Forson, the then majority leader, and then the Speaker of Parliament, where they were fighting over Article 96, 97, 98, whereby an MP want to cross carpet. What are they supposed to do? And then Speaker was of the view that when you are cross carpeting, it means that you are forfeiting your seat. And then Afenyomakin, Alexander Honorable, sorry, forgive me, Honorable was of the view that no, when they are doing that, it means that the effect has to take place in the next parliament. So you see all these things, but the question becomes, what was the idea behind the writers or the framers of the law? That's how we normally say them. The framers of the law or the writers of the law. What was the idea behind they bringing in that particular provision in the Constitution? So constitutional law goes beyond that written word. It goes beyond that written word. And then it goes back, it goes back to the idea for the creation of those written words. The creation, what happened? What is the history for bringing in those ideas or those inscriptions into the black and white sheet? What it was the idea? What at all happened? Are you getting it? So anything that is in the 1992 Constitution is in it because of a particular history. Because of a particular history. That is why it is in the Constitution. So we are saying that the Constitution, when we talk about constitutional law, it goes beyond those things, the hardbound document or the hardbound documents that we can see. It just goes beyond those laws that we see. And then it goes to the history of us, of the people. It goes into the history of the country. It goes back to the history of the ancestors of people who have existed. It goes back to the history that came or that served as the reason for the creation or for the penning down of those provisions. So that is constitutional law. That is what Jando and Graphics, they are trying to say. And then adaptation. The ones we have, the things we have adapted, or let me say the things we have gone through along the line, the metamorphosis that have happened within the law area and the arena, the ones we have also taken, we have adopted and adapted, are subject to Article 75. I don't know whether anyone is with the 1992 Constitution, Article 75, which gives permission. Please, if you are with the Constitution, you can open it. If not, I'm going. Article 75, which gives the permission to the president to enter into international conventions. And it is saying that the president has the right and authority to enter into international conventions and treaties, right? But subject to Article 75, Clause 2, it says that after the government or the president has entered into international treaties and conventions, those treaties and conventions are subject to parliamentary approval or parliamentary ratification or parliamentary ratification. And then when it comes down to the next clause also, I think clause 3 or the paragraph, it says that the parliamentary approval or parliamentary ratification can only be done by not less than half of the members in the of the members of the parliament. I hope you are getting it. So that is the law. That is what the law actually says. So that is how it is. That is what the law actually says. That is what the law says. So if you are doing it, you have to understand. So if you have opened to the Article 75, you can read it for us. Article 75. Anyone with an 1992 Constitution can read for us.
75.
So you can repeat. You can repeat. Which part are we reading?
Article 75 of the 1992 Constitution.
Good.
Say the president may execute or cause to be executed treaties, agreements, or conventions in the name of Ghana. 2. A treaty, agreement, or convention executed by or under the authority of the president shall be subject to ratification by A, an act of parliament, or B, a resolution of parliament supported by the vote of more than 1/2 of all members of parliament.
Excellent. So that is what we are saying. So when we are doing criminal law again, I will tell you, under the case of Techichu Kata versus the Republic or versus the state, right? Under the case of Techichu Kata versus the Republic, it was known, was it Techichu Kata? No. The case of NPP versus Attorney General. Yes, NPP. It was known or it was noticed that international laws, or let me say regional laws. In fact, because you are doing law, let me also let you understand that regional laws, when we talk about regional laws are different. Regional laws. When we talk about regional laws, we are talking about like the neighborhood, right? When we say regional, Burkina Faso, regional. When we say Togo, regional. I hope you are getting it, so I understand. So we are saying regional laws, or let me say even ECOWAS, let me say those things, or international bodies that Ghana finds itself in, their laws do not automatically become the laws of Ghana. I hope you are getting it. Their laws do not automatically, because Ghana is a sovereign nation. Their laws do not necessarily become the law of Ghana. Are you getting it? But the issue is, so we are saying that the international bodies or the international associations or whatsoever that Ghana finds itself in, their laws cannot automatically become the law of Ghana. Why? Because Ghana is a sovereign nation unless it is being adopted. So that is what we are trying to say there. In fact, the definition moves on. It says that by whatever means of institution and practices for the governance of a country. Institutions the rules of institutions, what governs institutions, labor commission, all of them. It is the constitution or the constitutional law. That is what brings all of these institutions and those. So that is what Jandor and Griffiths are trying to say. When we also look at definition of constitutional law by Munro C. In his book, What is a Constitution, 1983, Public Law, at page 563 to 564. Munro C. He says that a constitutional law is the body of rules, principles, practices, and attitudes relating to the creation and implementation of the system of government. That is the structure, functions, and powers of the organs or centers of power for the management of the public affairs of a state, for other entity or organization, African Union, their relationship with each other and the citizenry or members, and among the citizens or members. Aya, Munrosi, Munrosio, Munrosio, Munrosi, Munrosi. So that is Munrosi. Munrosi is talking. He said that when you talk about constitutional law, it embodies the rules, principles, the principles of the people. Ghana here, we cannot just take trumu, how do we say it? Homo LGBTQ. We cannot accept it. No, because our principles, what we were born into, what we have experienced in our societies, do not allow us. So our principles, practices, what we have been doing over years, what we keep on practicing becomes our convention. Our practices do not allow that. Our practices, what our ancestors have been doing, what we have been born to, do not allow that. Our practices and attitudes relating to the creation. Why did we create labor law, a labor commission? Why did we create forestry commission? Because we know that one day, there are some people who will be cutting walls, who will be cutting down woods or logs or whatsoever illegally. Why did we create mining, the mining sector or whatsoever? Are you getting it? Just because we know that one day, there are some people who are recalcitrant and they will come and behave some way. So we look at attitudes, principles, rules, practices. That is what Murosi is saying. Murosi is saying that the constitutional law of a country is not just a hardbound document, but it is the rules, it is the practices, even if it is not written, even if it is not explicitly written. So are you listening? So one day when you become a lawyer and then you are fighting for a case, you are trying to go for constitutional interpretation, and then, or you are fighting over something, you have to take into consideration the principles of the people, the practices of the people, the attitudes of the people, the culture of the people, the convention of the people. Are you getting it? You take all of them into consideration. You use that to fight against or to challenge the constitutionality of the matter that you have sent to court. Are you getting it? So under constitutional law, we are saying that it is not just the law, just the law like that. No, you must pay attention to the attitude of the citizens of that country. You must pay attention to the principles and practices of the citizens of that country. You must pay attention to the things that the people cherish so well, their culture, their customs, their how their ethnic groups and those things behave. Take them into consideration. Take them into consideration. That is how it is. Take them. All right. So that is it for constitutional, according to Munrosi. That is what Munrosi is saying. The body of rules, principles. And then he continued by saying that is the structure. So because of our principles, because of our practices, because of our attitudes, it is helping us to get the structure. The structure. It is because of this that we get to know the structure of governance. Let us get 4 arms of government. 3 arms of government: the legislature, the judiciary, the executive. Okay, the executive is going to be the president, who is going to be 3 things: head of the state, head of government, and then the chief commander of the army, right? The president, according to the Supreme Court ruling, the president as the head of state cannot be brought to court. The government or the president as the head of state cannot be brought to court, but the president as the head of government or governance could be brought to court. So that is how it is. So you are trying to say that it is because of all this that has been taken into consideration that is helping us to create or to get the structure of the organs or of the systems, and to be able to come up with their functions and everything. Another definition by A.V. Dicey in his book Introduction to the Study of the Constitutional Law explains it as follows. It explains constitutional law as the rules regulating and affecting the structure and power of government, which are enforceable in the law courts, in the courts of law. So they are the rules regulating and affecting the structure and power of government. They are the rules regulating and affecting the structure and power of government, which are enforceable in the court of law. So they are the rules that are regulating and affecting constitutional law. It should be able to affect the structure and the power of government. We don't leave one power in one person's hand. The person says, I won't hand over. I heard some not long ago. If this person wins, I won't hand over. You won't hand over. Where are you now? Don't hand over. You will see. So that is the law. The one who is seated on it, when it is time for him to also to go, he will go. In fact, it was his time he left. And now he has come back. So that is how it is. It is affecting the power of government, which are enforceable in the court of law. That is A.V. Dicey. If you are following all these definitions, starting from Jandor and Griffiths, coming to Munro C, now to A.V. Dicey, you could see one thing, that all these definitions are trying to describe. They are not telling us what exactly a constitutional law is. They are trying to describe. They are just trying to tell us. They are just trying to explain, like they are describing it. They are not just telling us exactly what a constitutional law is. When you say constitutional law, what exactly is a constitutional law? They are not giving us all these informations. All right. So, in all, what have we seen so far? In summary, we have seen that when we talk about constitutional law, we are talking about rules that are affecting the structure of power of governance. They are rules that are affecting the structure of power of governance. Rules affecting the structure of power of governance. So that is how it is. There are rules that are affecting the structure of the power of governance. It is because of the 1992 Constitution. That is why we are getting all the governmental institutions. And then that is what we use to appoint leaders and then also remove leaders from office. Let us quickly look at what Kofi Kumado. I like this man. Kofi Kumado. In his book, A Handbook of the Constitutional Law of Ghana and its History, at page 4. How many of us here have seen that constitutional law is becoming like, I don't know whether it is some history or it is some it looks like it is a philosophy or whatsoever. What people have said is what we are looking at. Yes, that is constitutional law. Right? That is constitutional law. Because a lot of people have sat down, they have observed a lot of things, and they have come up with ideas concerning this topic. So Kofi Kumado said that the constitutional law of a country will also embrace the principles of law embodied in the judgment of the relevant courts of law of a country over time on issues of governance. This is Kofi Kumado's definition. It's trying to let us know that a constitutional law is the one that the court says it should be. Say Kofi Kumado is restricting constitutional law to the judgment of the court. He is restricting constitutional law to the judgment of the court. Remember, when we go to the court decision is called ratio decidendi, right? Ratio decidendi. So from today going, when we hear ratio decidendi, it means that it is the decision of the court. Ratio decidendi. Others will say ratio decidendi. So ratio decidendi is the judgment of the court. So instead of saying judgment or the decision of the court, a lot of lawyers will say ratio decidendi or ratio decidendi or the ratio of the court, the ratio, right? And then in the course of the judges making decisions or making judgment, sometimes they bring in accidental and incidental statements, which are not parts of the judgment. They are not parts of the judgment. For example, because you are not beautiful, you, the lady, you are not beautiful enough, and the guy also has wasted your time. I will try and then give a proper judgment, a proper reward of judgment in favor of you, so that you'll be able to go and get married to different man. So you see that it is not part of the judgment, but it's just trying to bring it as an accidental and incidental. We call those ones obiter dictum, obiter dictum, obiter dictum, obiter. So forget about them. I just want you to know the term as we move along. So the decision of the court is called ratio decidendi or ratio. Are you getting it? That is how it is. So say Kofi Kumado is trying to let us know that when we talk about the law, constitutional law, it is all about the decision of the courts. It's all about the decision of the courts. All right. Now, before I continue, let me pause here, take your questions, one or two questions, and then we continue with the narrow and broad definition of a constitution. Remember, all that we have done so far is we have introduced the topic, and then we have also explained constitutional law. In fact, we are on the explanation to constitutional law. Then after that, we come to the characteristics of constitutional law. We have looked at Jandor and Griffiths, his explanation to constitutional law. We have looked at Munro C, his explanation to constitutional law. And then we have looked at this man, A.V. Dicey. Then we have looked at Kofi Kumado. What they are trying to let us understand is that constitutional law goes beyond the constitution, the hard-bound constitution we are seeing. It goes beyond the black and white sheet we are holding. It takes into consideration the principles, the practices, the conventions, the attitudes, the history, the culture, the custom of the people. It makes sure to consider all this and then bring them into consideration for a judgment to be able to be made appropriately. All right, let me take your questions. Your questions are welcome. So quickly, we are looking at the narrow and broad definition of a constitution. Wow. We have narrow and broad definition. What therefore is the narrow definition of a constitution? And what is the broad definition of a constitution? So when you hear constitution, it has a broader definition and it also has a narrower definition. When, according to Kofi Kumado in his book, A Handbook of the Constitutional Law of Ghana and Its History at page 3, the narrow definition presents a constitution as a document. So when you see constitution, the one you are holding, the black and white sheet, it is the narrow definition of a constitution, because it is just talking about a book. It is talking about a document, right? It is talking about a series of documents. That is what it is talking about. That is the narrow definition, right? But when we talk about, but when we talk about the broad definition of constitution, it refers to the entirety of all the rules. Are you listening? Entirety, right? Entirety of all the rules, attitudes, principles, practices, and norms that operate within a particular legal system. Rules, attitudes, practices, principles, norms, which is culture and custom, that operates within a particular legal system. So within a particular legal system, the rules, the attitudes, the principles, practices, and norms, they might not necessarily be written down on a on a sheet, right? But they form part of the constitution. I don't know the council. As I'm teaching them, the laws will be coming. Council, are you there? The one with the constitution, the 1902 constitution. Go to Article 11. Article 11. As I keep on teaching, then the laws will be coming. That's how it's supposed to be. When you move on, the laws will be coming. Article 11 talks about the sources of law in Ghana. For the laws of Ghana shall comprise of this constitution. Let us go. Are you there?
Yeah, I'm here.
Let's go fast. Cancel.
Okay. Article 11.
Yes, dear.
The laws of Ghana shall comprise A, the Constitution, B, enactment made by or under the authority of Parliament.
If you don't understand anything, Ghana legal system, here, this is the birth, this is the womb of Ghana legal system. Ghana legal system. This is the womb. You should know, you must know, you must know this. So the laws of Ghana, the constitution, A, B.
B, enactment made by or under the authority of Parliament established by this constitution. C, any orders, rules, and regulations made by any person or authority under a power conferred by this constitution. D, existing law. And E, the common laws.
Let us go to Article 1, Clause 2.
Article 1, Clause 2. The Constitution shall be the supreme law of Ghana, and any other law found...
No. Sorry. Article 11, sorry. 11, the 11 you have, Clause 2.
Okay, Article 11, Clause 2.
But by the way, Article 1, Clause 2 is telling us that among all the laws that you give, the Constitution is the supreme. I hope you understand. I don't know whether you are getting me.
Okay. Yeah, we are getting it.
Okay, so Article 11, Clause 2. I just want to pick something from there.
Okay, so Clause 2 of Article 11 reads, the common law of Ghana shall comprise the rules of law, generally known as the common law. The rules, generally known as the doctrines of equity, and the rules of customary law, including those determined by the Supreme Court of Judicature.
Okay, God bless you. In fact, later on, I'll come and analyze this one for you very well. Very, very well, especially when we're doing Ghana legal system. I'll analyze them for you very well. But look at it. It says that customary law. Did you see customary law there?
Yeah, it's there.
Customary law is there. So when the traditional people are saying, "Asasi ya, take alcohol, yeah. Asasi ya, take alcohol, yeah." That was what they used to scare the white people. The white people say, in those days, in the colonial days, all right. Then you see people who are busily pouring, like the alcohol that you want to drink. You are pouring it on the ground. As I say, I take alcohol, yeah. As I say, I take alcohol, yeah. Then the white people will be standing there and say, what is it? So in those days, issues relating to land matters, they used to let the local people to sit on those matters because the Asasiya in those things, the white people didn't know. So what we are trying to say is that customary law, the Constitution give high regard and high recognition to customary law. And then because of that, you can't just talk about constitution without paying attention to the custom, to the norm, to the culture of the people that the Constitution governs. That is what I'm trying to use to support. So that is the call for the norms that operate within a particular legal system. Hence, it refers to the entirety of the book of rules, the body of rules. It refers to the entirety of the body of rules. It refers to the entirety of all the rules, attitude, principles, practices, and norms that relate to the creation and implementation of the system of government. So the broader definition of Constitution is that it is the body of rules, principles, practices, norms, attitudes that are there for the creation and implementation of the systems of government. It is not just placing emphasis on any document. When you talk about broader definition, it is not just about the Constitution, the one you are holding. The broader definition goes beyond that. It is not placing emphasis on a book containing a constitution or some laws. No, the broader definition does not pay attention to just a book. Anytime a case appears before the court takes into account the culture, history, and the background of the people. Yes, it takes. That is why one of the cases, I will search for it and then give it to you. I don't know whether it is 24 versus Attorney General. It was I will never forget this judge, Judge Sowa. Judge Sowa, Justice Sowa said that the Constitution is a living organism capable of growing. And then, I hope you are getting it. He said the Constitution is a living organism capable of growing. So the Constitution keeps on growing. It keeps on. And not long ago, Justice Akufo, the former Chief Justice, also said that the Constitution it is dynamic. And then it is growing. So now it is becoming useless. So it has to be nurtured. It has to be fed. It has to be catered for. So Justice Akufo, what she was saying, I read it somewhere. Yes, I read it. I just have an excerpt of it. So that is how it is. The Constitution focuses on the culture, the history, and the background of the people. That is to say that they, which is the court, when they are determining a matter within the Constitution, they go beyond just the black and white sheet of the Constitution or the book that contains the law. They, however, place an emphasis on the spirit of the Constitution. So I think in the case of 24 versus Attorney General also, or NPP versus Attorney General, I think one of them, it says that the spirit, the Constitution has a letter and it also has a spirit. So the letter is what you are seeing, what you are reading for me. That is the letter. And then it also has a spirit. The spirit is the aspirations. It is the hope of those who wrote the Constitution. It's the hope of the people of Ghana. I hope you are getting it. It's the hope. So the spirit is talking about the hope of the people of Ghana. Now, Sir Kofi Kumado, in his book, A Handbook of the Constitutional Law of Ghana and Its History, at page 3 says as follows in relation to the broad and narrow definition of a constitution. He says that a close examination of the two definitions shows that the broad definition reflects the nature of a constitution, while the narrow definition reflects the form in which the rules of the constitution have been captured. The form in which, so the narrow focuses on the form, whilst the broad focuses on the nature. Number 3 item, subject to our objective for today, is characteristics of a constitution. Characteristics of a constitution. Characteristics of a constitution. Number 1, a constitution is a product of a constituent power. What are we trying to say? We are trying to say is that it means that it is something that originates or emanates from the people themselves. Cancel Article 1 clause Article 1 clause 1. Article 1 clause 1. Cancel. Please be helping us fast, we beg. Article 1 clause 1. I'm not having my constitution here. All these things are coming off head. That's why I'm not reading them myself. So Article 1 clause 1, cancel.
Article 1 clause 1. The sovereignty of Ghana resides in the people of Ghana, and in whose name and for whose welfare the powers of government are to be exercised in the manner and within the limit laid down in this constitution.
Thank you. So constitution is a product of constituent power. It means that it is something that originates or emanates from the people themselves. The sovereignty of Ghana resides in the people, period. So it means every constitution could be properly interpreted by considering the history of the people it governs. So if you don't take the people's history, background, customs, culture, and everything into consideration, you might interpret the constitution wrongly. Chief Justice Mashar, in the case of Mabry versus Madison, 1 Crunch 137 2L 860, the rest, that is citation, describe a constitution as the original right of a people to establish for their future government such principles as in their opinion shall conduce to their own happiness. It means that the constitution is there to make the people it governs happy, not to be a tyrant or like not to be like a monster. No. Characteristics of a constitution. Number 2, it is a fundamental law of the land, and therefore all other laws derive their validity from it. Article 1, Clause 2. Council. Council, today you are delaying me. All right. So what's your Article 1, Clause 2? Council, can you hear me?
Article 1, Clause 2. My network, sorry. Article 1, Clause 2. The Constitution shall be the supreme law of Ghana, and any other law found to be inconsistent with any provisions of this Constitution shall, to the extent of the inconsistency, be void.
Very good. So the supreme law is the Constitution, and all other laws must align to the Constitution. So Constitution is the fundamental law of the land, and therefore all other laws derive their validity from the Constitution. Article 1, Clause 2. It also contains the idea, aspirations, and values of the people it is enacted to govern. So when you go to Article 35, which is chapter 6, Article 35, you will see it. Thank you for that. All right. Characteristics of a constitution, number 4. Characteristics of a constitution, number 4. It also contains information about how the government is structured. Yes. It is because of the constitution. That is why it is because of the constitution that, how should I put it? It is, how should I put it? Okay, it is the constitution that has taught us how the government of Ghana is supposed to be formed, or it is the constitution that has directed us the structure or the structural arrangements of governance. You have to pick Council of State, you have to pick ministers of state, you have to pick this body, you have to pick these people, you have to pick cabinet, you have to do this. It is the constitution that tells us. So the constitution contains information about how the government is structured. It contains the right and obligation of individuals, the right and obligations of individuals. What the president is supposed to do, what chief justice is supposed to do, what speaker of parliament is supposed to do, what is required of a speaker. There are a speaker, or let me say a parliamentarians, MPs, parliamentarians have limited rights, whilst the president has absolute rights. For the president, when he is on the seat, both criminal and crime cases, you can't send him to court. For when we come to MPs or member of parliament, for they have limited protection or limited rights. Number 1, when they are in parliament, you cannot arrest them. When they are in parliament, you cannot arrest them. If you want to do it, or if you want to invite them, invite the person through the speaker of parliament. First right, he has 3 rights or 3 protections. Number 2, when he is returning from parliament, from his official duty to his house on his way, you cannot arrest him. Number 3, on his way to parliament to attend official matters, or to attend meeting or official meeting on parliament, or let me say, when he's going to work. That is their work. So when they are going to work on their way, they can never be arrested. So going, coming, and then also during, you cannot arrest them. They have limited powers. So that is how it is. All right. It contains the right and obligation of individuals. It also contains the rules regulating how it will be amended. Constitution itself contains the rules of how it will be amended. The same constitution will be amended. When you go to the latter part of the constitution, we also have entrenched provisions, all of them. The constitution also includes the practices, attitudes, conventions in the legal system. Characteristics of a constitution. Conventions are those, remember I've spoken about convention, right? But what are conventions? Conventions are those rules understood and implemented for some times, though they are not legal rules, but might have gained a widespread approval. So when you say convention, when you hear by convention, it means that the thing, it is not a rule, but we have been doing it. You have been doing it, right? We have been doing it. Possibly anytime you order something from Kiku, when they come, they call you and say that leave it at my door, and then they leave it at your door. Or when you order something from Jumia, they come to your house and then they call you and say, oh, leave it at my door. Then the following week, you say, leave it at my door. The following week, they call you, say, leave it at my door. The following week, they call you, say, leave it at my door. Almost 4 times. When they come, they can decide not to call you again. When they come, they leave it at your door. When they come next time, they leave it at your door. If thieves possibly and probably come and steal it, you cannot blame them, because by convention, you always let them leave it at your door. So conventions, it is not a rule, but the more you do it, it becomes part. It is a soft rule though. So from evidence, even though the conventions might have gained a widespread approval and recognition, they are not enforced by the law. I hope you are getting it. So it is not something that the two of you have agreed on. So we have the soft and then we have hard laws. Remember, we look at the law from the narrow and broader. Narrow and broad. Narrow talks about the document, the book. The broader talks about the practices, the body of rules, attitudes, principles, conventions, norms of the people, right? Then we are on the soft and hard laws. When we talk about soft laws, these are the conventions that people approve and regard, but are not enforceable in the court of laws. So they are conventions. That is what we have been doing, That's how we do it, That's how we do it, But it doesn't mean that it is by force for everyone to do it. That is how we do it, That is how we do it, But it doesn't mean that it is by force. I hope you are getting it. Hard laws, these are the ones that are regarded, approved, and enforceable in the law courts. So hard laws are enforceable. Soft and hard laws. That is where we are. That is how we are. Sorry, that is where we are. So critiques of the definitions of a constitution. The constitution as seen cannot contain everything. If it were so, there wouldn't be need to pass acts. Constitution does not contain everything. That is why the sources of law, according to Article 11, it also talks about the Act of Parliament. So Constitution doesn't contain everything. If it were so, there would be no need for Acts of Parliament or statute to be passed. So Constitution critique number 1, it doesn't contain everything. This means the 1992 Constitution does not cover every issue. Number 4 of our agenda for today is sources of constitutional law. Source of constitutional law, we have organic law or legislature, which is the court act and those things, organic law. We have judicial decisions, not just any judicial decision, but decisions of the courts on issue that relate to the Constitution, Article 2, Clause 1. So those ones are also sources of law, where the decisions of the courts. Don't forget what A.V. Dicey said. A.V. Dicey. What A.V. Dicey said. or was it A.V. Dicey? I think it was A.V. Dicey. He said that the constitutional law is the decision of the court. So don't forget. You have customary law, article 11 clause 3 of the 1992 constitution, customary law, you could see that. We have common law. We have textbooks of recognized and authoritative scholars. All of them give us what is called serve as a source of law. Now, I think we can conclude on what is called classification of constitutions. It is lengthy, but forgive me. Let's go. Classifications of constitutions. Number one, we are saying that the classification is based on the relationship between the legislature and executive, which is parliamentary constitution system. When we are looking at the relationship between the legislature and the executive body, right? We are saying that parliamentary constitution, we have what is called parliamentary constitution system. Executive is answerable to and is controlled by the legislature. When you go to UK, you will see this thing there. Are you getting it? When you go to UK, executive is answerable to and the executive is controlled by the legislature. It means that the legislature can pass a vote of no confidence, which will result in the dismissal of the executive, So under the parliamentary constitution or the system, executive is answerable to and is also controlled by the legislature. So the executive has to consistently and periodically appear before the parliament and then give an account. So under the 1969 Constitution of the Republic of Ghana, the Prime Minister executive was a member of parliament and therefore answerable to parliament. The 1969, at least you have gotten one characteristic of one thing about the Ghanaian constitutional history. 1969 Constitution, the executive was a member of the parliament, prime minister, and was answerable to the parliament. Now, presidential constitution system. Presidential, we look at parliamentary, we just look at parliamentary constitution or parliamentary constitutional system. And then here we are on presidential constitutional system, where the president, which is the executive, is independent of and is separated from the legislature. The president or the executive is independent. Example is the US Constitution. The next classification of constitution based on how rigid it is and how flexible it is. So rigid and flexible. And then monarchical and republican constitution, presidential and parliamentary, unitary or federal, single or multi-party constitution, and diachical constitution, written or unwritten constitution, bicameral or unicameral constitution. So looking at rigid and flexible, we are saying that this constitution is done on the basis of the difficulty or otherwise of amending the constitution. If it is so hard to amend the constitution, then it is a rigid constitution. But if it is not hard, but it is easy to amend the constitution, then it is flexible. Thus, classification is based on the amendment process of the constitution. So whether it is rigid or flexible, we look at the amendment process of the constitution. Amendment process, emphasis on amendment process of the constitution. So flexible constitutions are relatively easier to amend. Flexible. Rigid constitution involve an elaborate process for amendment, which may include a popular referendum. So very soon you will start seeing some of these things. Referendum. We take referendum before you can amend those things. So you look at the entrenched provisions in the 1992 constitutions. You will see them. So an example of a rigid constitution is the 1992 Republican Constitution of Ghana. So Ghana, it is a rigid. Then the British Constitution is the flexible type, the British. Thus, a special amendment procedures such as referendum involving the whole body politics of the country is required. So when you look at the Ghanaian own, you have to conduct referendum and those things before you can. And then another classification based on monarchical and republican, monarchy and republic. When we talk about monarchical and the republic, here we are looking at the classification based on the process or how in which the head of state comes into office, the process of which a head of state comes into office. Monarchical and then republican. We look at how a head of state comes into office. So monarchical constitution, the head of state gets into office through inheritance. So when you go to, I think, is it North Korea or South Korea, something Kim, it is by inheritance, So that one. And then when you come to this country, Swaziland, not Swaziland, I think it is in Africa here, Swaziland, very close to South Africa. I think that one is a monarchical. And then when you go to our own England or English people, and also, I think that one also is a monarchical. Inheritance, the head of state gets into office through inheritance. And then Republican Constitution, the head of state is voted for and therefore gets into office through election. Remember that monarchical and Republican Constitution is by the process in which the head of state comes into office. Then flexible and rigid is by the process of amendments. Are you getting the keywords? Okay, good. So the rigid and flexibility focuses on amendments. Monarchical and Republican focuses on how head of state comes into governance. So monarchical constitution are constitutions that are based on a regime headed by a monarchy. So a monarchy, whereas Republican constitutions are constitutions with elected leaders. So anytime you hear Republic of Ghana, it means that we choose our head of state not by inheritance, but by voting. Are you getting it? So this is based on electability of political leaders or otherwise. Thus, in a monarchy, political power is exercised on the basis of a membership of a particular royal family, whereas in Republican system, legitimate political power is exercised only upon the conferment of such power through the ballot box. So you should understand. All right. Then the next classification of a constitution is unitary or federal constitution. Unitary versus federal constitution. This classification is also based on the distribution of power. Emphasis on distribution of power. Now, rigid and flexible, rigid versus flexible looks at amendments. Then monarchical and republican focuses on how the head of state comes into governance. Then unitary versus federal focuses on distribution of power. Is it centralized or decentralized? Thus, classification is based on centralization or devolution of constitutional powers. Unitary constitution, under unitary constitution, powers of states are vested in the central or national government. Example is Ghana. Ghana is a unitary constitution. Unitary constitution, under unitary constitution, it concentrates on political or governmental power in the hands of the central government. An example of a federal constitution is that of a unitary constitution is that of Ghana. Now, federal disperses power to semi-autonomous parts. In fact, I won't go far. When you look at US, US has states. When you come to Nigeria, Nigeria also has states. That is federal constitution. It disperses power to semi-autonomous parts. So executive power is distributed. Executive power is distributed between the national or central government and two or more authorities on a regional or providential basis. Example is USA and Nigeria. So that is how it is. So when we look at unitary versus federal, you're looking at how power is being distributed. When you look at rigid and flexible, you're looking at how the constitution is being amended. When you look at monarchical and republican, we are talking about how a head of state is being appointed. Please, I'm repeating myself over and over just because I want you to understand the secret behind all these things. When we look at single versus multi-party constitution, we are saying that this classification is also based on the freedom that the constitution grants to persons to form political parties and to partake in general elections. Freedom to form political parties and then to also take part in elections. Single party constitution allow only one political party to operate. Multi-party constitution allows more than one political party to operate. When we come to Ghana, it is a multi-party constitution. It allows more than one political party to operate. So when we talk about single versus multi-party, single versus multi-party, we are looking at how the constitution gives power to people to form political parties and to also stand for elections. We have what is called diarchical constitution, where governmental competence is divided between two or more authorities, but on a regional basis. Example, the lawmaking power in the country may be shared or divided between the executive, president, and the legislature, right? So this occurs whereby it is very hard to see some of these things, but as you see it like that, it is there. It is there. This is whereby some of the arms of government can creep into other arms of government. So you can see the parliament also serving as judges. So they can also judge, discharge, and acquit someone. And then sometimes the parliament can make laws. The executive, the president can also make law. That is diarchical. Each one, there's a creeping governance. Each one of them can go to each one of them's field. Then we have bicameral and unicameral. Unicameral constitution says that is a constitution under unicameral constitution provides for a single legislative chamber. A single. When you look at Ghana, Ghana is a unicameral constitution in the sense that the constitution provides for only a single chamber, legislative chamber. Yeah, Accra. Yeah. Wherever you are, if you are a member of parliament, if you want to do you have to pick your car to Accra. Whether you are a member of parliament for Boko Central, or you are for wherever you are, right? You have to come to Accra before you can do yeah. That is unicameral constitution. We don't have parliament in Kumasi. No, it is at only one chamber. But the situation whereby we have two chambers, or let me say two or more chambers, then we come to bicameral is two, bi means two. So when we have two chambers, it becomes bicameral, right? Such as upper and lower chamber. We have the main chamber, we have the supportive chamber. That one becomes bicameral chamber. So when we look at unicameral and bicameral, we are looking at the number of chambers that the state has. All right. Then we come to almighty written and then we come to the almighty written and unwritten constitution, which also then we have the almighty written and the unwritten constitution, which also emphasizes on the classification based on whether the constitution is being contained in one document or it is not contained in one document. So when the constitution is being contained in one document, then it is a written constitution. And then if it is not, and it is scattered in different several laws like US, United States, like Nigeria, then we are saying that, for written, we have United States and then Nigeria. And then when it is scattered like the Britain or the British Constitution, then we say that it is unwritten. So unwritten, it is, as the name suggests, unwritten, it is not written. For the written, it is written. All right. That is the end of constitutional law for today. So in our next, we are going to assess some of the cases such as 24 versus Attorney General, and then the rest. So we are going to do a lot of things. So that is how it is. Once again, my name is Possible, and I've been your tutor up to now. If you have any question, I'm giving you just a minute or two for you to ask your question, and then we look at the way forward. Thank you for your attention and your obedience. In fact, your commitment, your diligence. Thank you for that. Yes, your questions are welcome.